Imagine this for a second. You vote in your local election, say for mayor. Your candidate wins, clear victory. But then disaster. Turns out they were ineligible, maybe lied on their form, something like that. They get disqualified. So the winner's out. What happens then? Does the person who came second automatically step in? The runner-up.
That exact question, it's been a real headache in Philippine election law for, well, almost a century now. And today we're doing a deep dive into a huge legal decision that just completely throws out the usual answer. We're looking at how the Philippine Supreme Court recently decided to definitively abandon this old idea called the second placer rule for local elections.
Right. And our mission today is pretty clear. We want to walk you through the legal reasoning, the sources, unpack why the court made this move. It's more than just changing a rule. It's really about what democracy means, how we respect the voter's choice.
Exactly. The case we're focusing on is Datu Pax Ali Mangguda Datu versus the Commission on Elections, or COMELEC. That's the elections body. This ruling came down April 22, 2025. And honestly, it fundamentally changes the rules for mayors, governors, councilors, you name it, across the country.
Okay, let's start with the basics then. Before this big change, what exactly was this second placer rule? How did it work?
Well, you could think of it as a sort of judicial shortcut for administrative convenience, really. If the person who got the most votes was disqualified later, or maybe their candidacy was canceled, basically their win was nullified. Then the rule said the candidate with the second highest number of votes automatically got proclaimed the winner. They'd take office.
So let me get this straight. Candidate A gets a 55% but is disqualified. Candidate B with maybe 40% just gets the job, even though most people didn't vote for them first.
That's precisely it. And for years, that was the accepted way. It was solidified in cases like Los Jos Jr. v. Comelec back in 2012. The thinking was, look, there's a vacancy, it needs filling fast, and the next best person is the one the second biggest group of voters chose.
But Mangguda Datu just threw that whole idea out the window. So what's the new system? What happens now when the winner is disqualified?
Okay, so the Supreme Court, it was an 8-5 vote, so quite significant. They declared that rule unconstitutional. No legal basis. Gone. For local posts, anyway. The big change is what replaces it. Instead of the runner-up, the court said you have to use the existing succession rules. Those are found in Section 44 of the Local Government Code, the LGC.
Section 44 of the LGC. Can you break that down for us? What does using LGC succession actually mean in practice?
Sure. It means we stop thinking about it like the election just defaults to the next person in line, vote-wise. Instead, when the winner's election is nullified, it creates what the law calls a permanent vacancy. So if it's the mayor, the LGC says the elected vice mayor takes over automatically. For other positions, there's a clear hierarchy defined in the code. It's about government continuity using established structures, not, second-guessing the election results.
This is where it gets really interesting looking at the court's reasoning in our sources. It wasn't just tidying up rules. They had three really powerful arguments for ditching the second placer rule. Let's tackle that first one.
Okay.
The idea that the rule just wasn't based on any actual law.
Yeah.
The statutory argument.
Right, and the court used this phrase, erroneous judicial innovation, strong words. They did a deep dive into the laws, the Omnibus Election Code, OEC, the LGC, even the Constitution, and found absolutely nothing. Zero text authorizing, proclaiming the second placer.
Hold on. If it was used for so long, even upheld in 2012, how could there be zero legal basis? Where did it even come from?
It seems it kind of emerged from early court decisions, almost out of convenience. But interestingly, even way back in 1929, there was a case, Nouveau v. Gouret. And even then, the court noted this rule didn't really have clear support in the statutes. But over the years, courts just kept using it because, well, it seemed like the most practical way to fill a vacancy quickly. It became a sort of judge-made tradition, but Congress never actually wrote it into law.
So the court's basically saying, look, judges can't just make up election rules. If the legislature wanted the runner-up to win, they'd have said so in the OEC. They didn't, so we've been following a ghost rule.
That's a great way to put it, yeah. They explicitly called out the Los Jos ruling from 2012 for trying to justify it. The Mangguda Datu decision is crystal clear. If it's not in the law passed by the legislature, the courts shouldn't be enforcing it, especially when it touches something as fundamental as the right to vote.
And that lack of legal basis feeds right into the second reason, which I think is the heaviest hitter, the constitutional argument about republicanism, the will of the people, sovereignty itself.
Absolutely, this is the core of it. The court said installing a runner-up goes against Article 2, Section 1 of the Constitution, the part that says sovereignty resides in the people. An election is about choosing who you want most. When that top choice gets invalidated because they were never really eligible, the votes cast for them, they're essentially treated as stray votes, votes for a non-candidate.
So not just wasted votes, but votes that legally couldn't count towards picking a legitimate winner from the pool.
Exactly right. And here's the key distinction the court made. The people who voted for that disqualified person. They were specifically choosing that person over everyone else, including the runner-up. So if you then install the second placer, you're basically forcing a leader onto the majority, or at least a very large chunk of the electorate, a leader they actively chose not to put in the top spot.
That really gets at that idea of a negative mandate, right? That voting for candidate A is also implicitly a vote against candidate B taking the top job.
Spot on. The election is about who you prefer most. Candidate B getting the second most votes doesn't translate into a mandate to govern if the winner is disqualified. If the winner's votes are stray, the election effectively failed to produce a winner chosen by the majority or plurality. You can't just say, oh, well, second place it is. That undermines the whole point of suffrage, according to the court.
Okay, let's get into some of the legal weeds mentioned in the sources. There were different ways a winner could be disqualified, canceling their certificate of candidacy, COC, under Section 78, versus other kinds like under Sections 12 and 68, or something called quo warranto. Could you quickly clarify those?
Sure. It's a bit technical, but important. The old confusion came from trying to treat these differently. So Sections 12 and 68 disqualifications often relate to, say, election offenses, or maybe having a criminal conviction that bars you from office. It might happen during the campaign or after. Section 78, the COC cancellation, is different. It means the person was never actually eligible to begin with. Maybe they lied about their residency or citizenship. It's like they were never a real candidate. And quo warranto is a specific legal action challenging someone's very right to hold the office they occupy.
And the old system tried to say the second placer rule might apply differently depending on which of those was used.
Yes, exactly. And that leads us straight into the third major reason the court gave for abandoning the rule: public policy and avoiding confusion. The justices basically said trying to parse these different disqualification types was just creating a mess.
A mess how? What kind of problems did it cause?
Well, the court pointed out that keeping the second placer rule could actually incentivize, let's say, strategic behavior, gaming the system. Imagine someone runs knowing they have an eligibility issue, they win. Then they get disqualified. And guess what? Their runner-up ally, maybe someone who knew about the issue all along, just slides right into the seat. The court called this kind of thing potentially leading to absurd outcomes, rewarding trickery almost.
That makes total sense. It discourages running clean campaigns. You're essentially rewarding the person who didn't win the most votes just because the actual winner had a flaw.
Right. And apart from those strategic risks, it was just plain confusing in practice. The court flatly said that trying to make distinctions between Sections 12, 68, and 78 had just bred a confusion and inconsistent rulings in the lower courts and Kamalak. By switching to the LGC succession model, you get one standard, predictable process. It doesn't matter why the vacancy occurred, it's clean.
So predictability and constitutional purity won out over speed. Okay, let's pivot to what this means going forward. For voters, for candidates, and local races, what's the bottom line from Mangudadatu?
The big takeaway is clarity and consistency for all local positions. Governor, mayor, vice mayor, councilor across the board. From now on, if the winning candidate is officially ruled ineligible or disqualified, you don't look at the runner-up, period. You look at the LGC's line of succession. It becomes an internal government process, not an electoral one.
And just to be super clear, this is definitely for local elections, right? Does it impact national races, like for Congress or the Senate?
The ruling itself is focused squarely on local elective positions governed by the LGC. Now, the court did discuss the constitutional principles, like sovereignty, which obviously apply broadly, but the specific mechanism for filling vacancies in Congress, for example, often involves special elections or different rules set by law. So while the spirit might apply, the direct legal change here is for local government.
And are we seeing this new rule being applied already? The sources hinted at some immediate effects.
Oh, absolutely. It's already impacting ongoing election disputes. There was mention of a contested race for Manila's 6th district and likely others from recent elections. Before Mangudadatu, the second-place candidates in those situations would have been arguing they should take the seat. Now, that argument is off the table. The courts in Kamalek will direct them to the LGC succession rules, probably meaning the highest-ranking counselor steps up or whatever the specific local rule dictates. It stops those second-placer claims immediately. Much clearer.
Now, we should mention it wasn't unanimous. It was 8-5. 5 justices wanted to keep the old rule.
Right.
What was their main argument? Why did they dissent?
The dissenters were primarily focused on practical governance, stability. They worried about leaving a post vacant while the LGC succession process unfolds. Their view was that installing the second placer, while maybe not perfectly reflecting the majority will, was the fastest, most efficient way to ensure someone was in charge providing services. They essentially prioritized administrative efficiency and avoiding a power vacuum over the majority's emphasis on the purity of the electoral mandate.
So efficiency versus the principle of who the people actually chose, or rather didn't choose, this whole deep dive really highlights a fundamental tension in law and governance, doesn't it? Moving away from what's quick and easy towards something that perhaps better reflects core democratic values.
That's exactly it. And it leaves us and you, the listener, with a really interesting question to think about. We have this tension. On one side, there's the need for government to run smoothly, fill posts quickly, maybe using the runner-up as simplest administrative stability. On the other side, you have this deep constitutional idea. Legitimacy comes from the people's choice, and the people didn't choose the runner-up for the top job. They actively chose someone else, or maybe just actively rejected the runner-up. So does respecting that negative choice, the fact they didn't pick the second placer, always outweigh the practical need for immediate governmental function? How do you balance those two vital needs in a democracy? That's the enduring question this ruling forces us to confront.